This is Building Tomorrow, the Society of Construction Law Australia podcast.
On the show, you'll hear real conversations about what matters most to the people behind the scenes who are shaping Australian construction.
From lawyers and contract administrators to engineers, commercial managers, consultants, and all the other experts forging the future of Australian infrastructure today. I'm Mawuna Matanda.
I'm BJ Lomsal.
And I'm Jennifer Raphael.
Sean Kelly is a partner at Clayton Utz in Melbourne, whose practice is exclusively focused on major construction and infrastructure projects, spanning through energy transition, resources, large-scale transport, and social infrastructure developments. He advises Australian and international project owners, contractors, engineering firms, and government agencies on all aspects of project delivery, from contract formation and risk allocation through to testing, commissioning, and strategic dispute management. Sean's notable work covers high-profile wind, gas, rail, road, hospitals, universities, stadiums, and defence procurement projects, with a proven track record in closing out complex issues and minimising disputes for his clients. In addition to his leadership in practice, Sean is actively involved with the Society of Construction Law Australia, contributing to thought leadership and industry engagement. Outside of his work at Clayton Utz, he also lectures on clean energy projects, law and regulation subject at the Melbourne Law School. In this episode, we explore the potential impacts of the upcoming Security of Payment Act Victoria amendments, focusing on key themes such as progress payments, performance securities, dispute resolution, retrospective application, and national law consistency. Sean is going to provide some practical insights into what these reforms mean for the construction industry going forward. Let's jump in. Welcome, Sean.
Thank you, BJ. Good to be here.
So let's start with setting the scene here. Why are these amendments here and why now?
The amendments follow a process with parliamentary inquiry and government response, which were largely targeted on achieving some solutions to a long-term problem in the construction sector, which is financial insecurity and insolvencies. As we all know, we've gone through a recent period of inflation spikes and cost escalations, and what that did was put pressure on industry sector finances, which caused a spike in insolvencies. And I think that is what has really put this back onto the agenda. A bit of context here is that the legislation was first enacted in 2002 in Victoria, and before that in New South Wales in 1999, and the genesis was from the UK prior to that. So the legislation has been around, and the purpose has always been about securing and improving cash flow in the subcontract chain on construction projects. What I think has happened is that over the course of 2 decades, all of the states and territories have diverged somewhat in the way in which they go about this particular policy objective. And then that divergence resulted in people in the industry, which is truly a national industry, raising some just complaints about the differences between the jurisdictions based purely upon the geography of a project. There has been for a long time, I would say 5 to 10 years, a growing push towards national unification so that the industry can achieve efficiencies across borders. But as I said, I think it was that recent spike in inflation which caused an increase in the number of insolvencies during the COVID years. So we're talking the last 2, 3, 4 years. I think that really put it back onto the agenda. And so coming out of that period of time, we saw inquiries into how this legislation in Victoria could be better improved through the prism of securing cash flow and giving greater financial security. That process lasted 18 months, 2 years. And now, as a result, Victorian Parliament, as we'll talk about in a bit more detail, is now debating a bill which will make some key amendments to the security of payment legislation in Victoria, designed primarily to achieve financial security in the contracting chain.
I see. You mentioned that a lot of insolvencies were happening. Was this down the chain with the subcontractors or not, or in the middle in the mid-tier range?
Look, the data suggests that there are thousands of insolvencies, and the reality is that most of those are further down the chain. But it's really the big ones which get the media attention. And I think what we've seen in the last few years is that there have been a few large main contractor level insolvencies over the last 3 or so years, which have really got onto the front page. And so it might be a case of the canary in the coal mine, where if there were insolvencies further down the chain, perhaps smaller businesses, maybe people weren't paying as much attention to that. But when it got onto the front page of the newspaper, it forced people to stand up and take notice. So definitely higher numbers down the chain, but what we're seeing is an increasing tendency of large construction firms also going insolvent.
Yeah, definitely not a lovely situation. It is quite difficult to work in those environments when you hear about stories when you get payment claims on 22nd December and you expect the contractor or the subcontractor to be able to work through that.
Well, we will see, BJ. We will see that when these amendments come in, that will no longer be the case in Victoria, and we shall cherish that moment.
I don't know. It could go either way, but let's discuss that further, right? Now, let's go through some of the key reforms that this amendment is proposing. Now, I understand the first one is the excluded amounts. Talk to us about what this means and what does the amendment propose?
I will, BJ, but before I go into that, can I just raise perhaps a couple of points by way of context?
Yep.
The first point I would like to make is perhaps some people view this as an issue as between the principal and contractors, and that there is a dividing line there between the claimant and the respondent. That is not the case. This applies to any construction contract. And so that could be a contract between the principal and the head contractor, or between a head contractor and a main package subcontractor, and then so on and so forth. So even a subcontractor on a large project might be the recipient of a claim, and so in that sense will be the respondent. And so just because you're not the principal on a project, that does not mean that you do not have to be aware of the consequences of failing to respond properly or on time. So I just wanted to dispel that idea that this is principal versus contractor age-old battle. Certainly not the case. This affects the whole chain, and everybody needs to be aware of what it means for them on both sides of the coin. So that's point number one. The second contextual point I'd like to raise is this, and it relates directly to what we're about to dive into, which is this excluded amounts regime. I would like us to conjure in our minds a comparison between New South Wales and Victoria. Broadly speaking, very similar jurisdictions, relatively similar populations, economies, relatively similar construction sectors, amount of work, etc. Both have security of payment legislation. So on its face, you would expect that there would be a relatively similar rate of use or nature of use of that legislation in both jurisdictions. That is not the case. We've crunched the numbers from FY23, which were the most recent available reports, and what we found was that in Victoria, there was less than half of the number of adjudication applications. What we also found was that in Victoria, the total cumulative value of adjudications in that reporting year was approximately 10% of the value in New South Wales. So we have to ask ourselves, why is it that in two roughly similar jurisdictions, there is such a large discrepancy between the number of adjudications and, more pronounced, the value of those adjudications? And the answer, quite simply, is the excluded amounts regime. So before we talk about the amendments, a little bit about the excluded amounts regime.
Yeah, what is this excluded amount regime? You've got me very interested now.
It is the key that unlocks a lot of things, and it unlocks understanding to these amendments and why now and what they're trying to achieve. The current legislation in Victoria includes the excluded amounts regime. As we will see, that regime is about to be removed root and branch. It's currently there, and the effect of this regime is that certain categories of claims on construction projects are excluded from the scope of security of payment rights and the adjudication process. So these include things like time-related claims, extension of time, delay damages, and also on the flip side, liquidated damages for delay. It excludes claims based upon latent conditions. It excludes claims based upon changes in law. It excludes claims based upon other factors such as damages for breach of contract. People with experience on construction projects know that these types of claims tend to be common and relatively high value. So what this has done in Victoria, it has actually taken a proportionately large volume of claims and an even higher proportion of the value of claims and taken them outside of the scope of this regime. The result is that it's really only payment claim disputes about the quantum of payment, but where there is otherwise no dispute about the underlying entitlement to that payment. It's only those types of disputes which in Victoria, until soon, were the subject of adjudication. What that has meant is that there's been a relatively low number of uptake and usage of the regime in Victoria, whereas in other jurisdictions such as New South Wales and Queensland, there is, as I said earlier, a significantly larger number of applications. The dollars are significant, tens of millions, sometimes hundreds of millions of dollars that go through this process. So far, Victoria has been immune. But what is about to happen, BJ, is that Victoria will be immune no more. And we can expect that in the name of improving cash flow and ensuring financial security in the construction sector, there will be a dramatic increase in the usage of this legislation, both in terms of the number of adjudication applications and also the value of them. So that will be a fundamental change, but what hasn't changed is the amount of time you've got to respond and the draconian consequences of not responding on time. Generally, the recipient of a claim will have 10 business days to respond with a payment schedule in which they have to explain, if it is the case, why they wish to pay less than is claimed. Now, you can imagine, BJ, that if there is a disputed variation claim or a disputed extension of time claim, which can be highly technical, responding fully in 10 business days can be difficult. And you may not get a full response in. If you don't get a response in at all, then the recipient is the subject of potentially a judgment debt automatically for the full value of that claim, or they put in a claim which may not be prepared to the best of their ability, and the matter might go to adjudication. And under the new regime, which will be enacted via these amendments, as part of that adjudication response, no new arguments can be raised. And so what we will see is, for obvious reasons, these types of claims will start to be made in Victoria as they are in New South Wales. Adjudications will determine those claims on an interim basis. It will involve large amounts of money. A number or high proportion of that value will be disputed. And so what I think we'll see is, unfortunately, an uptick in judicial applications trying to avoid or quash adjudication determinations. Now, the court system is already under stress because there's a lot of construction disputes at the best of times. I think what we will see is an uptick in the number of parties willing to go to court, even though getting an order quashing an adjudication determination is very difficult. A lot of the time parties will try. And if you follow the court lists in Queensland and New South Wales, there's always a constant stream of court applications seeking to quash adjudication determinations. And I expect to see that in Victoria coming soon.
You know, you're scaring me a little bit here because I used to work in Sydney for some time. And then I was familiar with the Security of Payment Act, generally speaking, as an engineer. When you get a claim, make sure you review that and get back to the subcontractor. And I've worked in Victoria as well, in the contractor space. Now, I wasn't aware of any of this, although I was aware of the act. And perhaps maybe at different levels, you need different levels of familiarity. But there is a stark question here. If you have to respond within 10 days fully, ideally, then the people that need to be the most across this change is not so much just the lawyers. It's the project managers that are on site. I mean, if neither party uses it, then maybe it's not a big issue, but it is not likely that neither party will use it. But then there's another issue here that if they're not going to apply it properly and then just run into this legal technicality issue all the time, do you think this change is actually going to make things worse or better? It's probably neither, but what do you think?
I think it depends upon which way you view it from. And I apologize for scaring you because I might have come across a bit alarmist because I was thinking as a litigator from the perspective of the courts and what I think will be an inundation of court applications. That's a unique perspective. Another unique perspective is cash flow in the construction sector and the necessity that parties to the construction sector get paid for the work they've done on time. Because we know on large projects, there might be 5, 6, 7 layers. And the reality is, if somebody's not paid at the top and they go insolvent, it doesn't matter what contractual rights sit underneath them. If they're insolvent, the parties underneath them won't get paid. So if we care about the financial health and the ability of our industry to continue to deliver incredible results, the reality is there needs to be a strong intervention in security of payment. It's in the name, and that's the purpose of this legislation. It's to unlock the ability of parties downstream to get their hands on cash flow. Now, if there is a disputed EOT claim or a disputed variation claim, very often prior to this legislation, that dispute will be used, bona fide though it may be, to deny payment downstream until such time as that dispute is resolved, which may be a year or 2 years' time, if the parties get that far. So the legislation recognises that in 2 years, the downstream parties might be insolvent, and that expertise may never come back. And that's not in the best interest of the Victorian jurisdiction and the construction sector in Victoria. So that is why the regime has intervened to set up an extra contractual process to get paid quickly. The key point here, BJ, is that it's not a final determination. This is only an interim determination for cash flow purposes. The legislation is very clear in terms of this cash flow and making a determination via an adjudication as to what amount of money is owed and then paying that on an interim basis. It is not determining final legal rights. If the parties think that the adjudicator got it wrong, then they are well within their means to commence a dispute resolution process in the usual way. The difference here is that previously, during the dispute resolution process, it was the party with the bigger balance sheet and more negotiating power who held the money pending the outcome of that dispute, which gave them a very strong negotiating position. It gave them the whip hand. The purpose of this legislation is to switch that, to give the downstream party access to funds pending the outcome of such future dispute. Now, what we see is, through lived experience, is that it's reduced the number of future disputes because a deal will be done if there is a genuine case that the adjudicator may have made a mistake or that there's been an overpayment. A deal will be done. It just means that the smaller party with the lower bank balance, the lower negotiating power, will have a fighting chance to hold on to some of that money instead of being forced or dragged through the dispute resolution process for 2 years and maybe never getting to the end.
In your article that you've published through Clayton Utz, there is a mention of unfair contract terms as well. We might get to that later on how this all unfolds. But let's move on now to getting rid of excluded amounts, I suppose. We've talked about it for so long, and hopefully we don't have to talk about it again. And I will make an observation that in New South Wales, this has been operating fine. So maybe there'll be a period of time in the industry where there is some turbulence. But what you've just mentioned about the security of payment/cash flow, I think that's a really good thing. And it should be the change for better. Well, at least that's the intent.
I think so. And it just means that there will be a period of confusion in Victoria as project participants who, and we're finding this, BJ, when we talk to our clients, there are some project participants who have rarely, if ever, used this legislation. And so they're going to have to upskill. And as you say, it won't just be the legal departments. Indeed, it won't only just be the project managers, it will be the finance departments and other people like that. So it will be a whole of business revolution in the way in which entities manage internally their projects. There will be a bit of confusion, and I'm quite sure that in the first period of time, there will be some parties who are just not ready, and perhaps they just don't respond within those 10 business days, or they don't say the right thing at the right time, and they might suffer some adverse consequences. I'm sure that will be the case. And the law there will step in to protect them if indeed they do have legal entitlements in that case. But in the long run, I think what you say is totally correct. Cash flow is for the greater good of the construction sector. For people like you and me who work in this sector, we need the sector to be healthy. We need people to have confidence to build projects knowing that they're not going to be rendered bankrupt because they've signed a long-term contract. So it is for the greater good. In the short term, there will be individual instances of what might appear to be unfairness or harsh outcomes. Yes, my hope is that the law can step in to smooth off some of the hard edges of those. Like I said earlier, it is very difficult to quash adjudication determinations, but not impossible. So the law does recognise that in some cases it can and should be done. And I hope that those people who feel aggrieved and who do have legal rights can access those rights. But I agree, I believe it's for the greater good. You mentioned, BJ, unfair contract terms.
Yeah.
This is an interesting one, and it does tie in a little bit with one of the philosophical items of background that I mentioned and that you mentioned in your opening gambit, which is nationalisation.
Yes.
So let's focus on that, if I may indulge you.
Yes, of course.
Two areas I would really like to talk about are two areas of intervention into contractual rights. One is the regulation of time-based notice provisions. The other is the rights that parties have to have recourse to performance securities. They may be insurance bonds, bank guarantees, retention monies, things of that nature. The legislation has moved beyond the immediate scope of payment disputes and gone into other contractual arrangements which Parliament appears to consider to be potentially unfair and therefore requiring a degree of public oversight, so to speak, legislative intervention into what would otherwise be regulated by private contractual rights. In respect of the first category, which is time bars, there is going to be a power vested in not just the adjudicators, but also arbitrators, judges, and experts appointed under alternative dispute resolution procedures to disregard the effects of a time-based notice provision if it's considered to be unfair or unreasonably onerous in its application on a particular case. Now, on its face, that might sound like it's a good outcome, at least for those who are well-versed in the industry like we too, BJ, because over the years, both of us will have come across numerous time-based notification clauses which appeared to be unfair. And so when you look at it through the prism of those examples, the result is that maybe for those, it's okay for somebody to step in and say that it's unfair. Personally, I don't think that the law was lacking in the way in which these issues were dealt with, there were ways around notice provisions and time bars, whether under the Australian consumer law, whether in estoppel, or whether by reference to some old case law from Victoria, the commercial purpose of contractual provisions. And when you construe a notice provision in a contract through the prism of the commercial purpose, sometimes giving a party notice at a site meeting which is properly documented in meeting minutes, sometimes that is sufficient even if it's not a formal bells and whistles piece of correspondence under the contract. So there are ample instances where the law, through various means, has knocked off the hard edges of contractual time bars, and yet there has persisted this belief that they are inherently unfair. And this legislation, once enacted, will, as I said, empower a large number of third-party determiners to disregard those provisions. Now, one issue that I see arising from this is that when you look at the indicia which will be taken into account to determine whether or not the provisions are unfair, there is no way that you can predict, in all honesty, in advance, whether a particular provision will be deemed unfair. And so the project managers will be left in a very difficult situation. Either they apply the clause ruthlessly and just say, well, under the legislation, if an adjudicator or a judge wants to form a different view, so be it. The alternative is to try to second guess what that adjudicator or judge or arbitrator might say. Now, the grave risk with that is that, as I said, the indicia of what is unfair or too onerous are very wide and varied, and it will be next to impossible to accurately guess which way it will go. And secondly, if a party to a contract does not apply the provisions of the contract consistently or at all, there is a very high risk of a waiver of legal rights. Now, that waiver will not be interim, which is the intent of the legislation. That waiver will be permanent. And so what I foresee happening here is that there will be a large number of project managers who might think that the legislation has, in effect, outlawed all of these provisions and that they can be disregarded. But that is not the case. It's only the case that the adjudicator, the arbitrator, etc., can disregard it if it's considered to be unfair or too onerous. I see a lot of parties inadvertently waiving full, final legal rights based upon a confusion as to how this legislation is intended to operate. So that will be an education piece, and that will be in the first couple of years of this legislation, making sure that parties know and understand that issue, that in my view, they should continue to apply the contract accurately and fairly, and don't try to second guess what somebody else might do in the future, because truly, we're not going to be able to do so.
I think this is a classic example of things are going on in the job site. We have a relationship to maintain. This is not just a one-time job. Let's look past this. And then all of a sudden, you've created a precedent in your contract where that can be relied on for the future when you're in the wrong and they're in the right, and they don't want to give you they don't want to give you the benefit of the doubt.
Exactly. And we've been through that, you and I and everybody else, numerous times. And I see an unintended consequence of this legislation will be to supercharge that tendency.
And another thing that I've noticed here about this notice-based time bias is when you have back-to-back contracts, say within the principal and the contractor, if you've got about 10, 15 days, business days to provide everything upstream, but then you need information from downstream, which might be several layers on a major project. And then now, once again, the time bar, by the time you are able to get the information back to you and then analyze all of that and put it back upstream, and before you can even put it upstream, there are several layers of managers you have to go through internally to actually be able to go through upstream, because it's a major commercial issue. And everybody has an interest when it's commercial.
You've raised a stunning point, BJ, because it is foreseeable with, let's say, for example, for argument's sake, 5 layers of subcontracts, that what might appear to be a very reasonable and fair period of time at the top, in order to make sure you get enough information from all the way down the chain, further down the chain, the time may be 5 business days. Because when you add it all up, 5 chains, 5 business days, 25 business days at the top, that might be reasonable at the top, but it might be unfair and onerous at the bottom. And if the party down the bottom, who is the one who is on site and has the information and can give it, if the legislation kicks in to say, well, that 5 business days is unfair and onerous and you don't have to comply with it, then that has cascading effects up the chain, such that the party who ostensibly has a fair period but can't comply with it because a provision downstream was found to be unfair. So I think there are a lot of uncertainties and practicalities that need to be ironed out. And unfortunately, it's just one of those things where you cannot craft perfect legislation which will solve all of these problems. And what we find sometimes is that when the legislature tries to solve a lot of problems, it can have the unintended consequence of causing other problems. How this plays out in the future, TBC. All I can recommend to parties is to continue to apply the contracts faithfully and reasonably and honestly, and don't try to second guess what this legislation might mean either for their contract from this perspective or for other contracts in the contracting chain.
That's really good advice. I'll be sure to remember that. Now let's have a look at some of the more simpler changes. Let's say introduction of a summer blackout period. Sounds fancy. Reference dates, all of these. What do they mean?
Fancy and beautiful, BJ. So as you highlighted in your introduction, there was a tendency, and I know this from lived experience, that the day before Christmas you would receive a payment claim, which would have to be responded to via a payment schedule within 10 business days. Now, of course, there are some public holidays over the Christmas and New Year period, but it's not that many. And it was not uncommon for project teams and their lawyers to have to work overdrive over the summer break period to respond. When these amendments are enacted, no more will that be the case. The period from the 22nd of December to the 10th of January will be a blackout period, and those days will not count towards the accumulation of time. So if you get served with a payment claim 5 business days prior to the 22nd of December, you can then take that period of time off, spend time with your friends and family, do whatever it is that you do over your summer period, and then you'll have another 5 business days at the end in order to lodge your claim. So that is something to be welcomed. The purpose of the legislation is not to trick people. It's not to create traps for people to fall into. It is bona fide designed to facilitate cash flow, and the amendments which are being proposed balance securing cash flow with a fair and reasonable application which is not designed to trick or trap the unwary.
There's other time-related things as well, which from a cash flow perspective, I think are somewhat tricky or could get tricky if it gets down to the wire. One of the things you've mentioned in your article is the shortened time frame to making progress payments. Now, if the progress payment needs to be paid within 20 business days of the claimant issuing a payment claim, now, does that start when the party responding to the claim received the claim? Is that correct? From the date when the claim is received, you have 20 days to pay? It's like 10 days to review and then 10 days to pay? Is that it?
Yes, and in theory, it should be the same day. So the day that it's sent and the day that it's received should be the same day. And indeed, other amendments in the Act modernise the manner in which payment claims can be served. And although it does not specifically say email in the operative provision, it does say in any way that a contract allows, and as we know, very often the contract will allow for the provision of documents via emails to the nominated project people. But in a notation in the Act, it does say, for example, it's expected that email service will be sufficient. So yes, it is designed to make sure that a contract could not say, as subcontracts did, you can put in a payment claim, then we'll consider it, then there'll be back and forth. And then when it's agreed, you can put in an invoice and then we'll consider it. And 20 business days after we receive the invoice, we'll pay you. It is designed to get around that situation. However, as you mentioned, we're talking about big dollars here, and companies can't just hand over sometimes tens of millions of dollars instantly. And so it is another example where parties are going to have to spend the time between now and when the legislation takes effect to really interrogate all of their commercial operations and their back of house operations, their finance teams, the channels of communications between legal, project, and finance all need to be clean, all need to be instant, because it is being brought down to the wire in terms of response times and payment times.
From a legal perspective, this is straightforward to understand, but from a practical perspective, even in my experience, it has to change from the top. I mean, if the principal is going to enforce a certain number of days before they do payment, then the contractor is going to have a similar one, not saying that that's the sole reason for it. My experience has been sometimes, let's say, 20 days, 30 days, 45 days, business days, even in some of the major projects. And that can get quite problematic for people downstream. And pay once paid is probably not going to be the norm now. That's probably my interpretation of it.
Well, but also just in terms of legislative consistency, pay when paid has been outlawed. So that was one of the original purposes of the legislation when it was enacted, now more than 2 decades ago, was to prevent parties from saying, you will only get paid when I get paid. So that's, a pay when paid provision, and that is illegal. And a clause which purports to do that is void. And so I think what happened was, in order to maintain flexibility, but in a way in which it wasn't, strictly speaking, a pay when paid provision, that's where we saw that drawing out of time periods, because it just gave more time for a party to receive payment before it was under a contractual obligation to pay downstream. Now that flexibility, so to speak, will not exist. And so this change is in alignment between that provision and the overarching purpose of cash flow and getting rid of pay when paid provisions, outlawing them. They're not, and since the inception of this legislation, never have been lawful. It will have consequences. It will mean that parties in the middle of the contracting chain will almost have to take a leap of faith where they have to pay downstream, and at roughly the same time, they're hoping that they receive payment from upstream. It will put the party in the middle of the contracting chain in a position potentially of more financial uncertainty.
The excluded amounts regime seemed to support pay when paid as well, if you ask me as an engineer. I mean, if so many things are excluded at any point in time, if it hasn't been pre-agreed, and if it's only the quantum that you are having a discussion on, in my view, that really didn't serve the purpose of the intent of the legislation. So I think, it is going to be quite an interesting change. All the time-related things, if everything happens from top down, this issue shouldn't arise at all because everybody pays and things flow up and down nice and easy, then everybody's singing the same tune. All right, look, we've had a lot of discussion so far on what has been proposed. Now let's look at the retrospective application before we move to the closing of the session. I think the retrospective application is quite interesting here. I'm reading that if the bill is passed, there is up until next September, which is 2026 September, to get up to speed with what is going to happen. Talk to us a bit more about what is this retrospective application?
Well, just to jump in there on the timing, it is expected that these amendments, once the legislation passes Parliament, that they will be proclaimed and will become operative in the early part of 2026. So that is an expectation at the moment. It's not a guarantee. The guarantee is that if it doesn't occur in the early part of 2026, it will be by no later than the 1st of September 2026. So people in industry listening to this should view September 26 as a long stop, but not as I've got until September 26 to get on top of this. You should be getting on top of this right now. The amendments could come into force a lot sooner than you think. To make matters complicated, the bill, which has been proposed and which is going through Parliament, has adopted, as you say, BJ, a retrospective application approach, which is most unusual. Ordinarily, legislation will be operative from the point in time it's proclaimed onwards, and that a party's legal rights historically will be regulated by the then current state of the legislation. And that is a question of general fairness. It would be unfair if a party's rights, which accrued 5 years ago, were based upon law which didn't exist at that time. It's particularly important in industries which are heavily involved upon contracts, which are, as we know, sometimes long and complex, and which are very carefully negotiated by sophisticated parties. Those parties have negotiated those contracts in the context of the law as it stands. Indeed, when this legislation, the Security of Payment Act in Victoria, was amended recently, so this is pre-COVID, those amendments were the subject of an express provision which grandfathered existing projects and construction contracts to the earlier version of the regime. That is very common. This legislation has not done that, and indeed has expressly said that it will apply, once enacted, to existing construction contracts. Now, there are some exclusions. So payment claims which have already been lodged and adjudications which have already commenced, when the new amendments are proclaimed, they will be subject to the old Act. So that means for an existing payment claim, excluded amounts regime will still apply. But for a new payment claim, albeit under the same contract, so literally could be the next month, it will be subject to the new regime. And in this case, there will be no excluded amounts regime applicable. And so that means that the project team and the finance team and the legal team have to be on it one day to the next so that they can immediately flip from one regime to the other, with the carve out of the pre-existing adjudication or the pre-existing payment claim. I do not envy the heroes in the project management team, because that will be a huge challenge for them to overcome. And that's why they need to start preparing now.
And there are so many different types of contract forms, and reading the research in Australia about so many contracts are heavily amended that there's not much point reading what's at the front page. Where did they take this from? It's a little bit scary once again. I've been scared twice so far in this podcast episode, but it's good to be scared. That way you pay attention, I think. That really brings the attention to the room, and top to bottom, everybody will read it and they will understand it, is the general expectation that comes to mind. There's another thing that I wanted to ask you, Sean. Now, this is a great opportunity for the Security of Payments Act to think about cross-jurisdiction. Before we get on to national, we are in the offshore wind industry infancy in Victoria, and there is a clear opportunity here for this act to interact with the federal legislation system. Maybe, maybe not. But once the projects do start, which we also discussed in class, by the way, earlier this year when I was a student in your class, is there an opportunity for this act to take the offshore wind projects along the journey as well? Or would it operate in a similar way that the oil and gas industry is operating, in an extremely well-articulated contract, which has very much of strong detail on how to do things if things don't go to plan? What's your view?
There is an opportunity. It's interesting that you raise oil and gas, because oil and gas is the subject of an express exclusion from security of payment. However, it is quite narrow. So it tends to be the extraction or the exploration for oil and gas and minerals. as opposed to all of the ancillary construction works which might lead up to that, which are still covered. Nevertheless, at the time when the legislation was first enacted, and this is a national approach, oil and gas and mineral extraction and exploration was excluded. But just to flag for our listeners, it's not a general exclusion to the whole industry. If you're in the oil and gas industry, as some of my clients are, I've been at pains to tell them, you will be doing things which will be construction works. It's just that the actual extraction of oil and gas may not be the subject of this regime. So that explains why oil and gas industry is a bit unique. Will offshore wind fall into the same category? Look, I don't know what the future holds, but I think it's unlikely. Can this regime extend to offshore areas and the potential intersection with Commonwealth waters? That is a very interesting question and one which a lot of grey hairs and brain cells might be spent thinking about. As we know, state jurisdiction just runs to coastal waters, which are a few nautical miles off the coast. And so therefore, on its face, the reach of state-based legislation runs that far. The security of payment legislation is a geography-based regime. And so what that means is that it applies to a construction project in Victoria. Wherever those works are done, so long as the projects are in Victoria, then the regime applies to those works. And this is important in the context of not just construction works, which are what we think they sound like, but related goods and services, which are things like surveying, design, architecture, sorts of things where you can provide related goods and services, not necessarily on the site of the project. So long as the project is based in Victoria, the regime will apply. For offshore wind, for example, as you know, there will be a lot of connecting infrastructure from the land side, substations on land, there'll be cables going out to subsea arrays, those cables and perhaps some substations at sea will be in coastal waters. So for those, there will be direct application of this legislation. For areas which are outside of state coastal waters, there is a particular regime in Western Australia which makes it clear that the exclusive economic zone, which goes out to 200 nautical miles off the coast of Australia, most of which is notionally under Commonwealth regulation, the legislation in WA makes it clear that the regime can extend out to that far. Now, similar provisions do not exist at present in Victoria, and they are not proposed via these amendments. So if we wanted certainty around that particular aspect, we would need to go down the Western Australian route. That has not yet been put onto the agenda. If we're serious about offshore wind or offshore projects, then I think it is something that we should seriously consider, speaking as a Victorian.
Well, I can read that there's apparently Tranche 2 reforms coming as well. So, it's never too late.
Never too late, but my understanding is they're not currently considered as part of Tranche 2, but never say never.
Indeed. Let's have a look at national while we are here on the topic. Any national implications that you see coming out of this amendment?
I think the observation, perhaps not an implication, but an observation is that while there is a growing chorus of industry participants who want a national approach, we see two things happening. One is that is gaining traction at the policy level, and we are seeing amendments which are specifically stated to be in favour of increased uniformity. So we saw that in Western Australia a few years ago, which dropped its West Coast model in favour of a model more akin to the East Coast model, which is now a distinction largely of no significance. And we're seeing it here in the Victorian amendments, which will get rid of excluded amounts, which were a unique feature to Victoria. So we're seeing a general move in the direction of national uniformity. But when you drill into the detail, and as we know, BJ, the devil is always in the detail, there continues to be a kaleidoscope of nuance and drafting and differences, which means that even though at a general level we're inching closer to national uniformity, we appear to be further away than ever. And it's things like the approach to time-based notice provisions which appear in WA and soon to be in Victoria but nowhere else. And in this current regime of amendments in Victoria, we have an intervention into contractual rights regarding performance securities, and that doesn't exist in other regimes. And in particular, the drafting of particular provisions is just different. And in a regime like security of payment, where the purpose of the legislation is to convey interim jurisdiction onto an adjudicator to make a decision, the precise drafting which defines that jurisdiction is critically important, because if the adjudicator is acting outside of his or her jurisdiction, they do not have the power to make the decision. And that is one way to quash a determination. Words matter, and the words in the legislation are different. The drafting is different. Different references to milestone payments, different references to how payment claims can be valued. Different concepts such as, do you have to give notice before you have recourse to performance securities? Well, in Victoria, soon enough, you will. Yes, we're heading towards something resembling national uniformity, but the closer you look, the more you start to feel that we may never actually get there.
Well, let's end in a much lighter note. I think that could be a good thing. Victoria could do some things better and maybe others will follow. You never know.
Well, they didn't follow with excluded amounts, but we live in hope, BJ.
I mean, excluded amounts, for what it's worth, probably had good intentions just to keep the fight separate and keep the goodwill under control. But it is what the industry makes it to be. The people that work in the industry, they bring life to the law, right? And hopefully when these amendments do come into effect, all of the retrospective applications, having to pay in a certain period of time, and then a long stop limit on making payment claims, which is, I think, 6 months. They're all really good things, trying to create uniformity across the chain, across the value chain, for a better word. And in my mind, that's going towards taking a step forward in the right direction, at least gives everybody hope. With everything, there is always some complication, some confusion, some mistakes being made. Somebody will try something. We don't know that. And you've also mentioned that just because you make a mistake, and if it's a genuine entitlement, you still have the opportunity to go back. Yes, it'll maybe take you longer, but you're not completely at loss here. So play fair, and you can expect to be back.
And BJ, before we wrap this up, can I just read back to you a beautiful sentence that you just said? It's those of us who work in the industry who bring life to the law. I think that should be the new catchphrase of the Society of Construction Law, because that is truly a beautiful thing.
Thank you. I didn't come up with that. It was on the fly. But that's what the conversation brought to me. It's very good to hear that so many people care about the businesses, which sometimes are just mom and dad businesses, We've got major contractors. Yes, they have a faceless face, but underneath there, I used to work for a contractor as well. I've worked both sides now, and we're all just people trying to do the right thing. And if there are contractual mechanisms that enable simplicity, and we don't have to hide behind the contract, it's using the contract because it exists and it's fair. And the fairer they get, the easier it is to implement, and everybody gets on board. At least that's what's my view. Great conversation, Sean. Any closing thoughts that you have?
No, I think I've peppered enough of my general philosophical musings throughout this conversation. I think it's a step in the right direction. Whether or not there were some missteps along the way, time will tell. I have misgivings around the intervention into contractual rights regarding performance securities. I'm an old-fashioned lawyer. I value freedom of contract. Is it the role of Parliament to mandate those sorts of issues when the law regulating recourse to security is so mature and so well understood? I'm not sure that was necessary. I think it will be very difficult to predict how the regulation of time-based notice provisions will play out in reality. But at a general level, cash flow is critical, and we've seen a step in the right direction to enhancing financial security in our industry. which of course is a necessary precondition for people like you and me to be able to do the things that we continue to do and love doing. Without an industry, I wouldn't have a job. And so I support any proposal which makes our industry healthier and more secure.
Definitely. And so it's the Security of Payment Act, right? That's what it's meant to do.
It's in the name.
It's in the name. All right. Well, let's conclude it there. Thank you for your time, Sean, and loved having you on the show.
Thank you, BJ. I appreciate being here, and I hope our listeners learned something out of this engaging discussion. Thank you.
Thanks for listening to Building Tomorrow, the Society of Construction Law Australia podcast.
The Society of Construction Law Australia is a national organisation of members at all stages of their professional career with a shared interest in construction law.
For more info about the Society of Construction Law Australia, head to the website scl.org.au.
This show was produced with strategy and production support from Wavelength Creative.
To make sure you don't miss an episode of Building Tomorrow, be sure to subscribe to or follow the show in your podcast app.
And while you're there, leave us a 5-star review. It really helps others find the show. I'm Mawuna Matanda.
I'm Vijay Lamsal.
And I'm Jennifer Raphael. And we'll see you in the next episode of Building Tomorrow.